नहीं दे रहे हैं।
बहुत अपनी सबसे
सॉल्व हो गया. Hello, are we audible?
Hello.
Can
Yes, sir. Yes, sir. You're
is
absolutely
the screen
audible.
visible, ma'am?
So screen is not visible.
Okay, so there may be some problem. I'm sending the PPT through your WhatsApp. Okay, please share it from your end.
दोबारा से एक बार स्क्रीन वो ज्वाइन करो ओपन करो स्क्रीन.
Hello.
Yes, ma'am.
Sir, you please close the window and open the PPT again. It will be visible after that.
Ma'am. Hello.
Hello, sir.
Actually, we are trying to share the screen, but it is not possible from our end. Okay, so I'm sending through WhatsApp.
Let me check, sir.
Yeah.
मैम को अलाउ करोगे शेयर वो करने के लिए.
Sir, we are doing some settings over here. Then it will be shared.
कोई बात नहीं फिर उनको
Hello.
जी मैम.
Sir, एक बार आप ट्राई करके देखिए सर.
Okay, okay.
Now it will be shared.
Is it visible screen? Okay, I've actually shared the PPT through Geeta, ma'am. Can you please share it from your end?
Now it's visible, sir?
Yes, ma'am. You may make it in a full screen mode.
Okay. So, shall I start, sir?
Yes, ma'am. Please start with the introduction part.
So, a very good morning to everyone. I, Dr. Anjali Sharma, on behalf of Guru Gobind Singh College of Pharmacy, extend a warm welcome to all of you who have joined today for this exciting and informative online workshop on intellectual property right. The workshop is jointly organized by Guru Gobind Singh College of Pharmacy and the Office of Controller General of Patent, Design and Trademark under the Department for Promotion of Industry and Internal Trade, Government of India. This event is an essential part of our ongoing IPR awareness program aimed at fostering a deeper understanding of intellectual property, particularly patents and design, and the significance in innovation, research, and entrepreneurship. For today's session, we have with us Mr. Ayush Mishra, an examiner of patent and design at Patent Office, Kolkata, West Bengal. I welcome you, sir. And secondly, we have with us Mr. Arnab Bhattacharya, examiner of patent and design, NIPAM officer, Patent Office, Kolkata, West Bengal. I welcome you, sir. We are truly honored to have eminent speakers today with us who are experts in the field of intellectual property. Their experience and knowledge will undoubtedly provide invaluable insights into intricacies of patent and design filings. Now, I request Dr. Geeta Deswal, ma'am, for a formal welcome address. Geeta, ma'am, please, it's now over to you, ma'am.
Thank you, Dr. Anjali. A very good morning, everyone. It gives me immense pleasure to welcome you all to this highly informative and timely online workshop on intellectual property rights, patents and design filing, organized by Guru Gobind Singh College of Pharmacy, Yamuna, Nagar, Haryana, in collaboration with Office of Controller General of Patents, Design and Trademarks under the National Intellectual Property Awareness Mission. On behalf of our college, I extend my warm welcome to our esteemed speakers for the session, Mr. Arnab Bhattacharya and Mr. Ayush Mishra. We are honored to have your presence today to enlighten us on the critical aspects of intellectual property rights, focusing on patents and design filing. Your knowledge and expertise will undoubtedly help the attendees better understand this important subject, contributing immensely to fostering innovation and creativity among participants. I would also like to thank the Department of Promotion of Industry and Internal Trade, Government of India and MHRD's Innovation Cell for their support in promoting IPR awareness through such initiatives. A warm welcome to all our participants who have joined us from various institutions, industries, and other domains. Your presence demonstrates the collective commitment toward embracing intellectual property as a tool for progression and innovation. Today's session is an excellent opportunity for all of us to gain valuable insights and practical guidance on filing patents and designs, which is an essential step towards protecting our intellectual assets. I encourage everyone to actively participate, ask questions, and make the most of this workshop. Once again, I extend my heartfelt welcome to all of you. Thank you and wishing you all a wonderful workshop.
Thank you. Thank you so much, Geeta, ma'am, for your welcome address and motivating the participants to hear enthusiastically. So, Mr. Ayush Mishra will be delivering a session on overview of intellectual property right. But before we get into the session, let me introduce our speakers whose guidance and expertise will play an instrumental role today. Mr. Ayush Mishra has a distinguished academic background with BTech in Electrical Engineering from NIT Durgapur. He began his career in the industry as an assistant manager at Bharat Aluminium Company, a part of Vedanta Limited in Korba, Chhattisgarh, before transitioning to the field of intellectual property right. His crucial role at Intellectual Property Office, Kolkata, involves key responsibilities such as patentability analysis of patent application and serving as an international search authority examiner. His expertise in searching and analyzing patent application make him an invaluable resource in today's session. We are grateful to have him here to shed light on technical aspects of patent filing and examination. Mr. Ayush Mishra, we are truly excited to have you with us today. Now it's over to you, sir. Ayush, sir, please.
Okay. Are we audible?
Yes, sir, you're absolutely audible, sir.
So, a very good morning to all the participants. Since the slide is being shared by you, so ma'am, I'll be requesting you to change the slide, okay? When I'll be telling you, okay? So today, good morning everyone once again. Today I'll be taking a workshop on intellectual property rights. I'll be discussing firstly, I'll be discussing what intellectual property is, kya hota hai intellectual property, and what are the rights that are associated or linked with intellectual property. So next slide. So first we will be discussing what is a property. Generally, any type of property is divided into two categories. Either it is a tangible property or it is an intangible property. Tangible property वो होती है जो हम feel कर सकते हैं, presence उसका हम देख सकते हैं. And intangible properties are those that are just made by the creation of minds, or they are made by using the human brain or human intellect. For example, when we talk about tangible properties, it includes, as you can see in the slide, gold, car, house, furniture, equipments. You can feel these equipments, you can feel the furniture, you can feel the car. So all these properties that is possessed by an individual or by a company is termed as tangible properties. But suppose an idea or some song that you are creating, some video that you are creating, that cannot be felt. You can just see it or you can just create it. So that type of property comes under the category of intangible properties. So example is inventions, literary and artistic works, designs, symbols. These all are intangible properties. Next slide, please. Just a second now. So what is an intellectual property? Intellectual property refers to the creation of mind, such as inventions, literary and artistic works, designs and symbols, names and images that are used in commerce. So intellectual property refers to any property which has been created by using human brain. As you can see, any type of property जो आप दिमाग लगा के या फिर अपनी creativity को use करके किसी property को possess करते हैं, that is called as intellectual property. And any rights that are associated with these intellectual property is called as intellectual property rights. So first, I stands for intellectual, that is possessing or showing some mental capacity. P is property, any item that is owned by a person or an entity, and rights is a legal entitlement that is accepted and protected by the law. So therefore, intellectual property right is a legal right that protects your intellectual property. Next slide. So first, discussing about the intellectual property, we'll be talking about the importance of intellectual property, why we are taking this session, why there is a workshop being created or being conducted on intellectual property rights. Because if we are कुछ अगर हम इसके बारे में पढ़ रहे हैं या फिर जान रहे हैं, then it must be having some importance. So first, the importance of intellectual property rights are: it first protects your intellectual property, it excludes others from making, using, selling, importing the patented product or process, then commercialization process, and fourth is it creates a business asset in the knowledge economy. So when you are possessing a right over a property, then you are the sole owner of that property. So without your permission, your property or anything that you possess cannot be used. So exclusiveness is provided by intellectual property rights. As you can see, the importance of IPR in the image, it protects your innovative idea. You can use that idea for commercialization purpose. I'll be discussing the examples where these intellectual property is being used for commercialization purpose. Then we can also use this intellectual property, like one of the intellectual properties, patents. Generally, various professors or research scholars, they are in the habit of uh, filing new patents or creating new IPs, so that they can improve their curriculum vitae, or they can write these that yes, I have this technology or this product patented under my name. So if that product or that property is protected, then it can be used for improving their they can use for improving their chances of getting a new job, or they can have their research papers published in various international journals. So you can see, when you have these intellectual property protected, you can have a lot of advantages. For example, as you can see in the slide, first you have to protect them, then as the protection, it excludes others from using or selling your product, and then you can use this for commercialization purpose. So next slide, please. So IP as a product, it can be sold, it can be bought, it can be leased on rent, it can pass under a will, or it can be assigned. So if you are the owner, you have the control, or you have the right of whatever you do with that property. Just like if you have a house, you can say, you can put it on rent, you can sell it, you can put it on lease, or you can pass it on to your future generation. Similarly, in analogus to that, IP also, intellectual property can be sold, it can be bought, and it can be passed through. It can be, for commercialization, it can be put on lease or rent, and it can be assigned to some other person also. Next slide. Now, what is the role of IP as an intangible property? It helps in creating economic rights of the creator, commercial exploitation of the owner of the IP, capital expenditure, transfer of technology, and cultural development. So this is the basic that I have told just in the previous slide. This is just a duplicate slide, that this is the role of IP as an intangible property, that you can have it, you can possess it, whatever you want to do with that property, you can do it. Next slide. Now, what are intellectual property rights? Basically, there are 1, 2, 3, 4, 5, 6, 7 intellectual property rights. First is the patents. Patents is basically for an invention or a product or a process. Second is yes, okay. So designs is for shapes, configurations, patterns, ornaments, or composition of lines or colors that are applied to any article. Then we have trademarks. Trademarks is basically a sign that is capable of distinguishing the goods or services of one enterprise from the other. Like trademark, very famous example is when you go to buy a laptop. While looking at the logo of the laptop, you can identify that whether this laptop is from Dell, or it is from Apple, or it is of Samsung, just by looking at the logo. So when companies, they make their products, they also apply for trademarks, so that their products can be identified and distinguished from the same kind of product. Then we have geographical indications. Any product that have a specific geographical origin and possesses qualities or a reputation. Means geographical indications basically is any product or any service that is present in a particular geographical region. For example, the Darjeeling tea. That type of specific tea is only found in Darjeeling. Or like the chicken work that is found in Lucknow, that is only present in Lucknow. So that area is being recognized or being identified by the product that product that is being made famous. So that type of products are also protected under geographical indications. Then we have copyrights. Copyright is basically for literary and artistic works, any sort of music or video or dance performance that any individual is making, that is protected under the copyright. Then we have semiconductor integrated circuits layout designs. As you know that a large number of ICs are used in electronic gadgets like phones, laptops. Then the placement of the various the placement of various components like the transistor, resistors, the value of these are protected under SICLDs. And then we have the last one, which has been recently added, is protection of plant varieties and farmer rights. Now I'll be discussing about them in the further slides. Next slide, please. So we can, by looking at this example of a Samsung phone, we'll be discussing that how all IPs are present in a single product. See, this is a Samsung phone. Next, please. See the trademark, as you will be seeing, trademark is the Samsung name. The Samsung logo is used for identifying the phone. That yes, the phone that I'm looking, or the phone which I'm trying to buy is from Samsung company. Then copyright the various software, the user manuals, the ringtones, the startup tone, the images. They comes under the category of copyright. Then the patent, the data processing method, the GUI, and the various software that are placed in the phone that is operating the phone comes into the category of patents. Then we have designs, the form of the overall phone, the arrangement of shapes of buttons, the curved phones that of Samsung that are very famous in recent times. They are all lying under the category of designs. Next, please. Then the SICLD, the placement of the various components on the motherboard is coming under the category of SICLD. So you can see 1, 2, 3, 4, 5. 5 IPs are present in a single product. We are using all products in our day-to-day life, but we are not identifying that what kind of IP is present in that product. So you can see in a single phone, you can find 5 types of IPs: trademarks, copyrights, patents, designs, and SICLDs. Next slide. So this is basically the gist of the intellectual property rights, that using your brain and various resources and the labor, you give birth to intellectual property, and protection of that intellectual property is intellectual property rights. Next slide. As I was telling about the utilization and commercialization part, after you are having or possessing the intellectual property, you apply for the intellectual property rights, you get the exclusiveness over that product, then that you can use this intellectual property rights for licensing or assigning that product to some company. You can franchise it, you can earn, like if I can tell you that the Mickey Mouse logo has been trademarked by Disney, and they have the Mickey Mouse logo which the Disney company is using have been trademarked for more than 100 years. They are being using it for more than 100 years. So you can see now the Disney brand is being identified by the Mickey Mouse logo or the Donald Duck. These all have created a franchise, that Mickey Mouse, Donald Duck, or any of the various characters. They all have been used for commercialization purpose. Various caps or various T-shirts are sold using that Mickey Mouse logo, and Disney earns a large amount of money from that IP. So that IP, that of Mickey Mouse or Donald Duck, they all are IP. They have been created by Disney, and now Disney earns a large amount of money from these franchises. Next slide, please. So first, this is the basic cycle of intellectual property. First, you create an IP. The green color, as you can see, the green color arrow is for creating the IP. Then you protect that IP. Then you utilize the IP, and then you enforce it. So this is the basic cycle of intellectual property. Next slide. So now we will be discussing about all the IPs in brief. First, we'll be discussing about patents. So what is a patent? A patent is a statutory right for an invention that is granted for a limited period of time to the patentee by the government in exchange of full disclosure of his invention, for excluding others from making, using, selling, importing the patented product or process. So basically, this is the definition. What I'll be breaking the definition word by word. So first, it is a statutory right that is granted for an invention. If you create a new product or a process, then the intellectual property that is associated with that product is patent. It is granted for a limited period of time. In India, if you get a patent, it is the statutory right is given for a period of 20 years. For 20 years from the date you have applied for the patent, you get it for 20 years exclusive rights. And it is given that who assigns the right to you? It is assigned by the government of India. And what you have to do as an inventor to the office, you have to disclose the invention to the office. You will be disclosing your invention. Full disclosure of the invention will be made to the government, and the government through our office will be making a decision that whether this product has to be given a patent or not. Second, patent is a territorial and exclusive right. Patent is a territorial and exclusive right. That is, it gives exclusiveness to the owner that yes, this is my product, only I can use the product, and it is a territorial right. That means कि अगर आपको patent India में मिला है, then that right is valid only in India. अगर आप चाहते हैं कि हर कंट्री में मेरा उस प्रोडक्ट के लिए राइट होना चाहिए, you have to apply for the patent in all the products. Like if you want your product to be protected in China, you have to apply for a patent in China. If you want your product to be protected in UK or US, you have to apply in all these countries. So patent is a territorial right, and as I was telling, it is granted for 20 years from the date of filing. When you file your application, from that day to 20 years, you will be getting the exclusive rights if the patent is granted. Next slide. Then this is the famous inventors and invention, like Mr. Thomas Alva Edison. You must have heard his name. He was the inventor of phonograph. Alexander Graham Bell invented telephone. Like Louis Pasteur, rabies vaccination. Alexander Fleming, penicillin. So all these inventions were made by these famous inventors, and what they did first is they protected their invention so that this invention was protected. So this invention can be protected, and it is then upon the user to decide that how he wants the invention to be made public, whether he wants to give it in charity or whether he wants that he will be charging a fees for using this invention. So it depends on the owner. Next slide. Like this is the famous invention of electric lamp. This was made by Mr. Thomas Alva Edison. It was granted on 1880. Next. The anti-gravity illusion shoes, the Michael Jackson shoes, which he used to wear, was also an invention that was also made in the year, I don't remember the year, but this is the application number. You can note the application number and you can check about what the invention was, what the features of the invention was, and it was granted the patent. Next slide. Now you must have seen that now the conventional stumps have been replaced by LED stumps. It helps the umpires to make the decision that whether the batsman is out or not. So this also was an invention that was made by an Australian inventor. His name is Mr. Braun Teckerman, and this was the application number. It was also granted a patent, and now what his company or Mr. Braun Teckerman's company do is they charge a large amount of money from the cricket organizing institutes like BCCI, Australian Cricket Boards, ICC, to use their stumps. If these institutes or these organizing institutes like BCCI, they want to use this stumps, they have to take the permission from Mr. Braun Teckerman, and he also charges a large amount of fees for using these stumps. Next slide. So not also we have some foreign inventors, we also have some Indian inventors like BEL, Bharat Electronics Limited. They invented the electronic voting machines. This electronic voting machines or EVM is being used for smooth conducting of the Indian elections. And this was granted the patent on 2005, and this was the application number. See, it was filed on 17/4/2001. From 17/4/2001 to 20 years, Bharat Electronics Limited were the sole proprietor, or they were the owner of this electronic voting machines. After 2021, this is now available in public domain, and anyone can now use this EVM machine. They do not need now any permission from Bharat Electronics Limited. For 20 years only, they needed permission from, or government of India needed permission from Bharat Electronics Limited to use this EVM machine. But after 2021, this is available in public domain, and there is no need of any sort of permission. Next slide. Now, we also have some young inventors like Vaishnavi. She is at I guess 7 years of age, and she has invented an automatic multifunctional life rescue flood house, and this was also granted a patent. So not only we have various big inventors or big companies, we also have young inventors or very young age students who are involved in creating new IPs, and this is recognized by Government of India. Next slide. See, like I was telling about young kids, see this Bengal kid, this bag's patent for his affordable touch-free portable hand sanitizers. After COVID, we are now used to using hand sanitizers, but this young boy, class 9-year-old student, has created a touch-free portable hand sanitizer. So he also got recognition. He also got a good amount of money he got recognition from the Government of India, from the Government of West Bengal, for making such inventions. Next slide. So this was all about patents. Next we have designs. What are designs? The features or shapes, configurations, patterns on ornaments or composition of lines or colors that is applied to any article, whether in 2-dimensional or 3-dimensional or in both forms, by any industrial process or means, whether manual, mechanical, chemical, separate or combined, when such that when the article is finished, it appears appealing to the eye. So कोई भी existing product में अगर आप उसमें किसी तरह का shape में change, उसके design में change या फिर उसके pattern में change लाते हैं, such that that change can be brought about by any process like manual, mechanical, chemical, electric, कोई भी process आप उसमें change लाते हैं, such that जो product final आता है, it should be appealing to the eye. If it is appealing to the eye, then that product gets the protection of designs. Like patents, इसके लिए भी protection जो होता है, it has a period of 10 years. It is for protection of 10 years. You are getting the full protection for 10 years, but it can be extended to 15 years. Next slide. As you can see, it is applied, the design IP is applied to any article that is pre-existing. For example, first we used to have a sofa set of 3 and 2 set, but now we have various shapes of sofas like L-shaped sofa, we have sofa cum beds. So you can see various modifications if you bring about in any existing article through any process, then also you can get an intellectual property registered by your name. Next slide. So you can see from this is a typical Coca-Cola water bottle, Coca-Cola soft drink bottle. It was, see, in the year 1899 to 1902 till 2007, there have been changes in the same water bottle. But so these all water bottles are registered under different names. So this is the power of intellectual property, right? That you can bring about change. That you can bring about changes in the pre-existing article by any process. You can see the process that which have been used in this would have been molding of glass in such a form such that it appears appealing. Next slide. Now, industrial design protection. Protection for industrial design that are new and original. Designs are features of shape and configuration, as I have told. It can be changes that you bring about in the shape, configuration, patterns and ornament. Design must be applied to an article and it should be applied by industrial process, and it should be appealing. The first and the foremost thing that it should be appealing to the eye. Next slide. Now we have designs of set of articles. Certain articles are present in a set. For example, when you go to buy a pair of shoes, अगर आप जूते खरीदने जाते हैं, then you will not buy a single shoe. You will be buying a pair of shoes, like the tea set or the sofa set or the ornaments that you buy. They are all part of a set. You do not buy an individual item. You buy it in a set. So set means a number of articles that are of the same general character, which is sold or intended to be used together. So these are also protected under the design intellectual property. Next slide. So you can see this was the original Coca-Cola bottle design. It was the US Patent Office granted design in the year 1950 to Root Glass Company in USA. So you can see this is the design that was granted in the year 1950, and till now there have been so much changes, as we have shown in the previous slide. So much changes in the design of the same same soda bottle. Next slide. This is the design certificate which is issued to the person who applies for the IP. You can see the Government of India issues the Patent Office Certificate of Registration of Design. You can see the signature or of the controller patents, and the time period has been mentioned that till 10 years you will be getting the protection of the design that you have submitted. Next slide. Then we have copyrights. What is copyrights? As I have told, copyrights is basically applied to any musical work, any book publications, any song that you have created, any video that you have created. Protection of such IP is done by copyright. So it allows the owner to choose the ways his or her copyrighted works are made available to the public. So when you have the product registered under copyright, the Copyright Act protects it, and it is now upon the user. The user can make the song or the music available to the public, or it can charge a fees. Like you must have witnessed or you have seen on YouTube that certain videos, if you try to create a video and you put some other song in that video, then there are certain copyright strikes because the owner of that song does not want his song to be placed in your video. So this Copyright Act allows the owner to choose the way his or her work is made available to the public. Next slide, please. So there are certain sections in the Copyright Act that is protecting various types of intellectual property, like the publications or the books that you write. Like this book of artificial intelligence that has been written, it is governed under section 2O. The dramatic works, the various dramas or theatre works are protected under section 2H of the Copyright Act. Next slide. Then the sound recordings, they are protected under section 2XX. The artistic works, the paintings or the various paintings of like Mona Lisa or the various Leonardo da Vinci paintings are protected under section 2C. Next slide. The musical works, the song that you create or the melody that you create is protected under section 2P. Then the cinematographic films, like the various films like the mention of KGF or any such, you must have seen a warning or the first warning that comes. It is that you cannot copyright the product or you cannot the product is protected under the Copyright Act. Which act? Under section 2F. The section 2F is used for cinematographic films. Then rights of the authors of copyrighted works. There are two rights that are associated. Economic rights, that is covered under section 14. It may be assigned to the other owners or a sum of money or royalties depending on the proposed usage of work. Economic rights, when if you have, अगर आपके पास आपका सॉन्ग रजिस्टर्ड है, उसको कॉपीराइट मिल चुका है, तो you can use that you can use the economic right power and you can sell that song or you can earn royalties on that song. Then there are certain moral rights. Moral rights is covered under section 57. These are non-transferable rights and they remain with the original author, but you can use these, you can use the product without any monetary after giving money. मतलब आपको कोई पैसे देने नहीं पड़ेंगे and you can simply use their product or use their song or the videos or the various song compositions. You can use them without the permission of the owner or the one who has created that product. Next slide. Now, just like for designs and patent, we also have term of protection for copyright also. Like for published literary and dramatic, artistic and musical work, we have protection of life of author plus 60 years. The cinematographic films and sound recording, we have 60 years from the date of publication. Like for broadcast reproduction rights, we have 25 years from the following year of broadcast. Then the performance right, we have 50 years from the year following the year in which the performance is made. So you can see for different types of intellectual property, we have different year of protection. Next slide. Now, who are all the authors of the work? Like this is a very basic, like who will be creating the musical work? It will be a music composer. A photograph, the person who's taking the photograph. Cinematographic film, the film producer. Literary artistic work, the person who causes to the work to be created. Literary or dramatic works, it will be the author. So, next slide. So the next is the SICLDs. Semiconductor integrated circuit means a product of is any product or a transistors that is a combination of various components. Like अगर आप जो भी कोई phone use कर रहे हैं, तो कोई भी electronic gadget use कर रहे हैं, they are now all a combination of three components, basically resistors, capacitors, inductors, or you have various op amps or the various components, they are placed on the IC. So the placement or the way the IC or the components are placed on the on the semiconductor device is semiconductor integrated circuit design, and the layout of these ICs is called as SICLDs, semiconductor integrated layout designs. So layout designs means a layout of transistors and other circuitry elements which includes lead wire, जो भी wires connecting है, जहां से connection किया गया है, resistors को कैसे जोड़ा गया है, capacitors को कैसे जोड़ा गया है, they are the layout of these designs is basically the layout, and SICLD is basically protecting such kinds of IPs. So we have the registry office in Delhi is where the applications on layout designs or of integrated circuits are filed for registrations. Next slide. This is the SICLD processing and use. As you can see, this is the fees. That application for registration of layout design is 5,000 rupees. Then the notice of opposition. This is basically the process. You can just, I'll be giving one minute time, and you can just see, look, that what is the process of filing the SICLDs. That first, the filing of application is done by the creator. Then the communication of objection is done by the patent office to the person who has applied for the application. Then registrar may accept or accept with some modifications or some issue. It can issue some hearing, then it will accept, and this is the process which is being followed for SICLD's registration. After hearing and after overcoming all the objections, the SICLD design or SICLD objection is being removed, and the certificate is issued to the applicant. Next slide. Now, next we have geographical indications. So basically, what is geographical indication? Geographical indication is an identification that identifies a product that have a specific geographical origin and possesses qualities or a reputation that are due to that origin. For example, मैंने जैसे बताया था कि अगर if a product is present in that particular region only and such that that region is identified by that product, कि चाय जैसे चाय पीनी है तो दार्जिलिंग टी is very famous, so that tea, that Darjeeling is being recognized by the Darjeeling tea. Or you can see the various examples like the Nagpur orange. The oranges of Nagpur are very famous. So the Nagpur is being recognized by the oranges that is found in that area. So like the Wayanad Jeera Kalsa rice, the chicken work that is done in Lucknow, the Nilgiri tea. These are all the famous products that are found in that region. So geographical indications are basically protecting such kind of intellectual property. Next slide. So as you can see, geographical indication, it is an indication. It originates from a definite geographical territory. It is used to identify agricultural, natural or manufactured products. The manufactured products should be processed or prepared in that territory. Very important is that it should be found in that territory only. And it should have a special quality or reputation of other characteristics. Next slide. Now, benefits of geographical indications. Registered geographical indications have exclusive rights to access or use GI products. As you can see, the GI products are very famous. जब भी कोई बाहर से या फिर tourist आता है, they usually buy these GI products. Like whenever anyone can go to Darjeeling or you can go to chicken work, then that region is identified by, yes, the chicken work of Lucknow is very famous or the Darjeeling tea is very famous. So it helps in creating an economic environment such that ki log aayenge, they will be spending a lot of money. It will be creating a sort of market so that their products get sold. Then it helps in legal protection to geographical signs in India. It prevents unauthorized use of registered geographical indications by others, and it provides legal protection. You get the protection of the various geographical signals get protected. It promotes economic prosperity of producers of goods produced in a geographical region. So these are the various benefits of geographical indications. Next slide. Next slide, please. So as I was telling you, the various geographical indications like the Darjeeling tree, the Ratlamil Save, these are all the examples. The Makrana marble of the Taj Mahal which has been built of. These are all examples of GI. Next slide. The Kashmiri saffron, the Naga mirch, the Telangana Telia Rumal, the Madhubani paintings. The Madhubani paintings are very famous. So these all regions, the Madhuban area is being recognized by the paintings that are made in that region. So therefore, these paintings are helping the painters of that region to get recognition. So therefore, geographical indications is playing a very important role in the lives of the painters of that region, of Madhuban region. Next slide. So the Sikkim's large cardamom, Nagpur orange, I have given the examples. The Tirupati laddu, the Bobili Veena of Andhra Pradesh, they are all have been recognized as GIs. Next slide. This is a GI certificate that is issued by the patent office, by the Geographical Indication Registry, which is covered under the CGPTDM only. This is the basic GI certificate which is issued. Next slide. So now we'll be talking about the validity. As I have told you, the patent, for patent it is for 20 years from the filing date. For designs it is for 10 years plus 5 years. The trademarks, it is indefinite, subject to renewal. You just have to pay a renewal fees and it can be renewed to indefinite time. For GI also it is indefinite, it can be renewed. Then for copyrights, as I mentioned in the previous slide, the slides will be shared to you. And for example, if you are having some confusion, you can note it down. And in the next, when Arnab will be taking the session, he will be discussing all the questions that are arising in your mind. Yeah. Next is SICLDs. 10 years from the date of filing and application for registration. For 10 years, originally it is for 10 years and then it can be extended. Okay. Then who can apply? Any person or legal representative or any person can apply for this. Then we have all IP rights are territorial in nature, as I have told you. Just a second. Hello. Hello. So as I was telling you that all the IP rights are territorial in nature. As I have given you the example of patents, where I have told you that if you want to apply for a patent in China, you have to file an application in China. Next slide. So this is basically the data of patent of various types of applications that are submitted in the office. Like for patents, as you can see, there have been a steep rise in the number of patent applications that are filed in India. Not only patents, you can see for design applications, trademarks, geographical indications, SICLDs. There has been a gradual increase in the number of IP applications that are being filed in India. See, as in the year 2018 to 19, only 4 lakh total 4 lakh applications were filed, but now in 2022-2023 6 lakh applications are filed. And after these sessions or various workshops, it is expected that by the year 2030 this figure can be easily reach to 10 lakhs or 15 lakhs. Next slide. Now there are certain points that I want you to remember, like first protect, then publish. First you have to get your product protected and then you publish the product. Then, as I've told you, the rights are territorial in nature. The registration in India is done by the government of India only. The rights are for a limited period of time, and renewal fees has to be paid for some IPRs. Next slide. Then there are various career opportunities in the field of IPR. Next slide. Like government job, like we are working as an examiner of patents and designs. Then we have examiners of trademarks and GIs. We have also examiners of copyrights. This is a Group A job. There are various benefits that you get after joining this job. Then we have jobs in private sectors also, like we have patent agents, trademark agents, GRF and SRF in patent facilitation centers. We also have patent litigations and other opportunities in private sectors. Next slide. So thank you. This brings to the end of the session. There will be a 5 minutes to 10 minutes break. And I request you that everyone kindly note down any sort of confusion that is coming to your mind. And these all questions will be addressed in the next slide, in the next session that will be taken by Arnab. So thank you for the session. Thank you.
Thank you. Thank you so much, sir. I extend my sincere gratitude to Mr. Ayush Mishra for delivering such an insightful and enriching session on an overview of intellectual property right. Mr. Mishra, your deep knowledge of the subject and the clarity with which you have explained the complex concept made the topic both accessible and engaging. Thank you, sir.
Okay. We are starting the next session within a few minutes, please.
There's a 10 minutes break, right, sir?
5 minutes will be sufficient, ma'am.
5 minutes.
Okay.
Okay, sir. After 5 minutes, we'll be having the second session by Mr. Arnab Bhattacharya, sir. So we'll meet after 5 minutes.
Is the screen visible? Can anybody? Ma'am, is the screen visible?
No, sir. It's
No,
not.
sir, it's not visible. Sir, please try now.
Okay. Is it visible now?
No, sir.
Okay.
Sir, we are sharing from our side.
Okay.
Now it's shared. So, welcome back all of you to the second technical session of the workshop. For this session, we have with us Mr. Arnab Bhattacharya. Sir will be delivering a session on patent application, filing and processing. Before proceeding with the session, let me introduce our speaker of the day. Mr. Bhattacharya has a Bachelor of Engineering in Electrical Engineering from Jadavpur University, Kolkata, and Masters in Technology from Indian Institute of Technology, Delhi. Before joining the patent office, he has worked as a senior engineer at Larsen and Toubro Construction Limited from 2015 to 17. Currently, as a patent examiner and NIPM officer, he focuses on prior art search and patentability analysis in the examination of patent application. His work and deep understanding of prior art searches will give us a critical insights into the process of examining patents and assessing their uniqueness. So it's our privilege to have you with us, sir, today. It's over to you, sir. Arnab, sir.
Arnab sir, are you there?
Ma'am, please unmute, sir.
Yeah, hello, am I audible? Hello.
Yes, sir, you are audible.
Okay, so thank you very much for this introduction.
Thank you, sir.
Okay, I welcome everyone to this session about patents filing and processing. So before starting so this session is actually all about the process of the patent applications, as well as before that, how the patent applications are actually filed in India specifically. Next slide, please. Hello. I think some network issues are there. I think some network issues are there. Hello. Okay. So the first and foremost is, what are the requisite documents or forms that are required for filing of the patent applications? So the first and foremost is the Form 1, which describes the details of the application, like who is the inventor and who are the applicants. Okay, so that details need to be filed in Form 1. And like for example, the applicant may be any educational institutions or any college, whereas the inventors can be of their students as well as their faculty members. So that details needs to be filed in the Form 1. The second part is the Form 2, which gives the disclosure about the invention. What are the technical features there that are associated with the inventions, like the title of invention, background of invention, summary of the invention, drawings, and other things that should be furnished in Form 2, that is the complete specification. Form 3 describes the, if a patent application is filed in multiple countries, so their corresponding details needs to be furnished in Form 3. And Form 5 is the declaration to the inventorship that this is my applicant and these are the inventors. Only the declaration needs to be furnished. But the most important part is the Form 18, or the request for examination. This is very much important with respect to the filing of patent applications, because unless and otherwise the Form 18 or the request for examination is filed, okay, your patent application will stop at the publication stages only. It will not proceed further beyond the publication. Okay, so Form 18 is absolutely necessary for further processing of the patent applications. And if the applicants are engaging any IP professional or patent agent, then Form 26, or the power of attorney, that needs to be filed during the patent filing process. Next slide, please. Next, please. Okay. No, previous slide, please. Okay, so filing procedure. So there are basically two types of filing procedures. One is the physical filing, that is filing all these documents as well as these forms in hard copy, and that needs to be submitted through the patent offices or the IP offices, which are located at Delhi, Mumbai, Kolkata, Chennai, and as well as in Ahmedabad also nowadays. So they can be they can be filed at the appropriate office based on the jurisdiction, which will be discussed in later stages. Or there exists a comprehensive e-filing portal or online filing portal, which is available in our IP India, Government of India website. Next, please. Next slide, please. Yeah. So this is the screenshot of the comprehensive e-filing portal. This is available in our IP India or Intellectual Property India website, which is the official website of the intellectual property of the Government of India. And you can file all the not only patent applications, even the other IP applications like designs, trademarks, GIs using in online mode only, and not only filing, all the subsequent processes that are involved in the filing and processing of patent applications can also be conducted in online mode only. Next slide, please. Yeah, and in case of physical filing, so the offices or the filing offices will be based out of jurisdiction wherever the applicant is or the applicant is residing or applicant is having a place of business. So for the western part of the country, the states of Maharashtra, Gujarat, Madhya Pradesh, that is majorly the western part of the country, will have to file for physical filing. They have to submit the documents to the Mumbai office. And for southern part of the country, they have to submit to the IPO Chennai. For northern part, the New Delhi is there. And for the rest of India, the northeast as well as the eastern part and the Andaman Nicobar Islands, they have to file in the Kolkata Patent Office. And for the design office, it can be filed physically at Patent Office Kolkata or any of its branch offices at New Delhi, Mumbai and Chennai. Next, please. So this is the filing fee. So the filing fees, it varies with the category of applicants, in which capacity the applicants are filing. If the applicants are filing as a startup, or if the applicants are filing as a natural person, for example, any individual applicant or any group of individuals, if they are filing, or if they are filing as a startup, or if they are filing as an educational institution, or if they are filing as a small entity like any MSME, so then they can exercise the option of having the of paying the very less filing fees. Okay, only 1600 filing fees are there. And if the applicant belongs to other categories like industrial bodies, okay, or any corporate sector, okay, or any other organization, then the filing fees will be 5 times higher. That is, the 1600 filing fees will become 8000 filing fees. And for Form 18, that is request for examination, the filing fees is 4000 for the startup or small scale, or educational institution or individual. And for the other applicants, it is 20,000. So the minimum filing fees, including Form 18, will come around 5600. And if the applicant is of other category, it will be around 5 times higher, which is around 28,000. Next slide, please. Okay, so see, the processing of patent application, which starts from filing and up to the last stage, that is grant or refusal, which is called as disposal stages. It involves several stages, which we shall discuss in the later part. But all these stages takes a considerable amount of time. Okay, it is variable. It can range from years also. But if the applicant wish that all these stages are processed in a very faster manner, okay, starting from the filing to the disposal, then they can exercise the option of expedited examination, filing Form 18A, that is request for expedited examination. But this Form 18A filing is only applicable for certain eligible category of applicants. Okay, so what are those applicants who are eligible to file this Form 18 or expedited examination? So the first category is any startup or small entity, they are eligible. Any individual or natural person or any group of natural persons wherein any of the applicant is a female, then they can have the option of filing expedited examination. Any government department, any government educational institution, any government company, they are eligible for filing in expedited examination. If the applicant has chosen India as a ISA or IPEA in PCT international application, they are also eligible. Or any other agreement between Indian offices and foreign patent offices, then also they are eligible to file through this expedited examination. Now, once this expedited examination is filed, then all the subsequent processes, hearing, FER, whatever it is there, will be conducted in a very expedited mode. And you may get get the patent application if found eligible within a few months also. So this is the advantage of having the expedited examination. Next, please. Okay, now coming into the technical specification, which is called as complete specification. That means what is the disclosure of your invention. Okay, so it can be filed in two modes, either in provisional specification. Provisional specification means a brief summary about your invention to be filed. Then the government of India will give you a 1 year time to complete the remaining part of your work about the invention, and within 1 year then you can completely disclose the invention. So what is the advantage of it? Advantage is that you can secure the filing date as early as possible, because the earlier the application is filed, the higher is the chance of getting the patent. Okay, because not only in India, in everywhere in the world, okay, they all follow the rule of first file basis. Whoever files early will ultimately get the patent application. If two similar applications are coming, so the one who will file early will ultimately enjoy the advantage of getting the patent, right? So, but the problem here is that your invention is partially completed, it is not yet fully completed. But if you want to secure the filing date in India, you can file the provisional specification. Okay, then you can enjoy. I mean, you not enjoy. Then you can have another year, almost a year of completing the remaining part of your work, and then you can file the complete specification. Okay, it is very much similar to having a learner's license, which is valid for 6 months, whereas the provisional specification is valid for 12 months. And then within 12 months, you have to file the complete specification. Then your application will be processed as in a usual manner. But also you can file directly the complete specification if you have completed your invention, which includes the title of the invention, the background, that means what are the existing problems or what are the existing problems of the technologies that are existing nowadays about your invention, and what problems you are trying to solve. Okay, so that needs to be mentioned, the technical problems that is there before your invention, and how your invention will actually solve those problems. Okay, so the aims and objectives, technical aspect, working examples needs to be filed. But the most important part of the complete specification is the filing of claims. So what are claims? Claims define the boundary of the invention. Okay, it is written in a very point-wise manner, and whatever you will write in the claims will be ultimately covered the scope of your invention. Okay, say for an example, you have filed a patent application about properties of metals. Okay, so metallic properties you have put, you have done the research, you have put the calculated results, and all these things we have written in the disclosures about your invention. But in the claims you have mentioned only copper as the metal. Okay, so your invention will be very then get limited to the metal copper only. Okay, it will not encompass any other metals apart from copper. Why? Because you have mentioned copper in the claims. So the boundary of the invention will be limited to the copper metal only. It will not encompass any other metals except copper. Okay, so this is the importance of claims. Okay, and the drafting is very much particular and very much essential. Okay, because it cannot be neither broad or neither narrow also, right? So it should be in a drafted in a very particular manner, so that the scope of your invention is very much neither too broad or neither too narrow. Okay, it should be very much suitable, and it will actually help you to get the patent. And apart from claims, other abstracts like a brief summary about your invention, the technical use and specific speculative use that needs to be mentioned, drawings that will help you, that will support your invention, and sequence listings are specifically for biotechs as well as for pharmaceutical patent applications. So these are the actually technical aspects about the disclosures of your invention, which is called as complete specification, which is filed in Form 2. Next slide, please. Okay, now coming into the processing stages. So patent applications are basically of three types. Okay, one is PCT applications, second is conventional applications, and third is ordinary applications. So PCT and conventional are useful if you are filing through multiple country patent applications. Okay, if you want to protect your patent applications in several countries, you need to file it individually, either because all the IP rights, okay, that has been discussed earlier, including patents, are actually territorial in nature. Okay, so the patent that is granted in India will be valid for India only. So if you want to protect it in other countries like US or Europe, you need to file separately the patent applications in those countries, and they will follow their own laws and regulations related to the patent protection. And if found eligible, then you will get the protection then and there only. But it can be done in either two ways. One is conventional, you can just hop in multiple countries directly, file directly, taking the priority. And the other is the PCT route, or the Patent Cooperation Treaty, where you need to file a common international applications. Then taking reference of that international application, you can go for the national phase applications in multiple countries. Okay, so but if you want to file your applications for the first time in India, then you need to choose the ordinary patent applications. Okay, so we are actually, for the sake of the simplicity, we shall take the case of ordinary applications and show how that applications are actually processed in India. Very similarly, it exists with the processing is almost similar with the PCT and conventions also. Okay, so the first case is ordinary. So either in ordinary applications, either you can file a provisional application if your research work has not yet, if your invention works has not yet completed. So you may file it in ordinary provisional specification and then file the complete specification within 1 year, okay, as per the rule. And you can also directly file the complete specification. Say, for example, you have directly filed the complete specification, disclosing all the aspects of your invention. So after 18 months, normally, it will get automatically published. Okay. So there is a huge difference between patent publications and research paper publications. Please try to remember, because in case of research publications, it is the final stage. Okay, after it is reviewed and all the checks are being made, and then only it is published in the final stages, right? But here the patent publication is just the opposite, that is the initial stages, whereas only few things are checked, whether your application belongs to defense or atomic energy or any such matter. Only these things are checked. If not, then whatever you have written is just published. Okay, then after you file the form 18 or request for examination, then the further checks are done, whether your invention is patentable or not, whether your invention has got some novelty, inventorship and other criteria or not. Okay, then proper examination is done after you file the form 18. Okay, it is done after the publication, not before the publication. Okay, so there is a difference between academic journal publication, which is the last stages, and patent publication, which is the final stages, or not final stage, which is the initial stages of the patent application processing. So after it is after 18 months, it is published. But if the applicant wish that it can to have the early publications, okay, for their own interest, so they can file their early publication form also. It is form 9, but it should be filed in a prescribed manner. That means it has got some filing fees associated with it. So early publication will be done, and then form 18 needs to be filed, request for examination. Then the application will process, or we will proceed to the examination stages, or wherein all the formal and technical examinations are being done, and the first examination report will be issued to the applicant. It will be sent to the applicant's email ID or whatever the registered email ID that they have provided. And the consolidated report about the patentability criteria and other things, objections are being delivered in the first examination report. Then the applicant will need to reply to the examination report. Okay, then they can reply to the examination report using 6 plus 3 months. That is, 6 months is the normal time, and if the applicant is not cannot file within that 6 months, then they need to file an extension, request for extension of time for 3 months using form 4, or if not further, they can also enjoy the benefit of again another 6 months from the by filing the petition and all these things. So the applicant needs to respond to the examination report. That is, they need to put their version, okay, about the objections. They need to reply to the objections raised in the examination report, okay, and then it will enter into again the examination stages, wherein their replies will be considered, okay, based on the objections raised in the first examination report. And if the officer who is in charge of, you know, who is in charge of taking a decision or disposing the application, either grant or refusal, if the officer is satisfied or the controller is satisfied that the reply is that the reply to the objections raised is satisfactory and no other objections are outstanding, then the controller can directly grant the patent. And if he or she is not satisfied, then another opportunity is given to the applicant in the form of hearing, where the applicant or their patent agent needs to attend the hearing in online mode only, and they need to provide their own arguments, okay, supporting their claims about the invention. Then after hearing, and if any outstanding objection is written, if they complied with it, and if the controller is satisfied, then after hearing, he or she can directly grant the patent, and if not, then the application will be refused. So this is the total stage of patent application processing, very simplistically if I put. Next slide, please. Okay. So now I have already spoken about the patent publications. Okay, so it is very much different with that of the research paper publication. So what are the things which are being checked during the before the publication? So before the publication, only basic screening is done to check whether your invention falls into the category of defense or is prejudice to the national security of our country, or whether your defense, whether your application falls into the atomic energy or related to the atomic energy or not. And if it is related, then it will be forwarded to the concerned department. For defense, we have got the DRDO, Ministry of Defense, and for atomic energy, we have got the Atomic Energy Department also. So then they will check technically, and if they have got any objections, then the publication will not take place. Okay, it may, if it is related to the defense of our country, then it will never be published. Okay, and if it is not, then ultimately it will publish. So the considerations of the DRDO and or atomic energies are taken, and based on the recommendations, the patent applications are published if it is found related to the defense or atomic energy at all. And if it is published, then after filing of Form 18, it will be allotted to the examination section. Next, please. Okay, so these are basic timelines which we need to comply. Okay, so for professional to complete specification, as I had discussed, it should be within 12 months. For Form 3, it will be for for multiple country filing, so it may not be useful at the stages. It should be within 6 months. And for proof of right, okay, who are the applicant and who are the inventors? The inventors, they need to give the declaration and also the assignment that the invention has been assigned by them to the applicant. Okay, so that proof of right needs to be filed within 6 months. And Form 26, if any agent is authorized, then it should be filed in a GPA mode or any power of attorney within 3 months from the date of filing of the specification. And Form 5, the declaration should be filed within 1 month of the filing of the complete specification. Form 18 or 18A, it is 48 months, but due to recent amendment in the rules, it has been changed to 31 months. So it should be within 31 months from the date of filing of the patent application. Now, reply to FER within 6 months from the FER issued date. Hearing submission, any outstanding objections are remaining after hearing, it should be filed within 15 days of hearing. Pre-grant opposition, it can be filed within grant, and post-grant within 1 year from the granted applications. Okay, so these are some basic timelines which the applicant needs to comply for filing and processing of patent application. Next slide, please. Okay, now coming into the examination section. So these are actually done by the patent office only. So just for the sake of clarity, better clarity, what are the things that are being checked during the examination stages and how the objections are prepared? So the first is formal examination and technical examination. Two types are there. So in the after checking or after examination, only the FER reports are prepared. So what does the FER report contain? So the FER report, which contains the gist of objections which are communicated to the applicant. And for the after the response is given by the applicant, again the examination is being done to check if any outstanding objections are remaining or not, and whether the reply is satisfactory or not. And if it is satisfactory, or if it is not satisfactory, then another subsequent examination report is generated. And another stage is hearing, which is the technical discussion on pending objection between the applicant and the hearing officer or the controller. And grant or refusal, it is the decision based on the pending objections and the submission of the applicant. So this is the final stage, grant or refusal of the patent application. Next, please. Okay, so for the examination section, what we need to conduct is that first we should try to understand the invention, about the drawings and what problems they are trying to solve, and what the claims are mentioned in the invention. Then we have to search for any relevant prior art documents. So what are those things? So that means any similar applications which have been published before the date of filing of patent application. Okay, whatever is published early in any format, we can cite it. Okay, similar citations, and we can just check it using the patent search process in any databases that we have. And after the similar documents are found, we just need to cite it, and what features are actually similar with that disclosed in that particular prior art citations, we just need to put up, and then we need to prepare the examination report. So that will be useful to ascertain the novelty and inventive step with respect to the citations. Okay, and the detailed examination report is prepared based on those observations. Next, please. Next slide, please. Yeah, next slide, please. It's already discussed. Yeah, so now we have the patent search meeting. Now we have got the patent search. So what is a search? A search is a prudent and cost-effective process of finding the published documents related to your research or invention. So as I have already mentioned, all those things which are published before your date of filing or before you have disclosed it, it can be treated as a prior art or the similar document. Based on the search results, you can determine whether your invention is patentable or not, and to what degree it is patentable. A search may help inventors to modify their efforts to improve the probability of getting a patent. Okay, next, please. Next slide. Yeah, so what are we searching actually? We are searching for similar documents. So these are called as prior art. So prior art is any evidence that your invention is already known. Okay, it need not to exist physically or to be commercially available. Okay, anything can be a prior art. Okay, a prehistoric cave painting, a piece of technology that can be centuries apart, any cartoon scene or anything which has been disclosed to any format can be treated as a prior art. Next, please. So what are the databases that we can use for conducting patent searches? We can also use the Indian patent published documents which are available in our IP India website. With that, the tool name is InPass. Okay, apart from that, we can use the USPTO, US Patent Office databases, European Patent Office databases, WIPO or World Intellectual Property Organization. They have got their own databases also. And very simplistically, you can also search in the Google Patents. Next, please. So apart from patent literatures, we can also conduct searches of similar documents using the non-patent literature databases like the research report journals and other things are there. Okay, next, please. So this is a screenshot of the InPass database of the Indian Patent Office databases. So it contains the details about the prior patent publications which are published in India, and from there you can check with the title name as well as the any features of the complete specification. You can check, and they will just provide the details. Next, please. So based on the search results as well as other outstanding objections, we just prepared the first examination report, which is sent to the applicant with the containing all the details or the outstanding objections which are observed during the examination of patent applications. Next, please. Yeah, so contents of APR, the first is technical objections, which deals with the patentability criteria like novelty, inventive step, industrial applicability, and the non-patentable like certain inventions which are not patentable in India, okay, like anything that is harmful to the human or animals, okay, any business method, any computer program per se, okay, or any traditional knowledge. So whether your invention, whether the contents of the application falls into this category, these things are checked in the technical objections. And whether there is a unity of invention also. Unity of invention means that one patent is granted for one invention, single invention. If your application contains multiple inventions, then a single patent cannot be granted. Okay, then objections will be raised regarding the unity of the invention. Then you just need to reply that how the multiple features of your inventions are linked to as formed a single inventive concept. Okay, so that things need to be checked in the unity of invention. Clarity and scope are also there, whether the claims are written in a clear, concise, succinct manner or not, whether these things are checked. And apart from that, formal objections are also there, like timelines, forms and fees, contents, drawings, format, power of attorney, whether all the documents have been filed and all the fees have been paid or not. That things need to be checked. Any other requirements like co-pending applications, like multiple similar patents have been filed. Amendments, whether the amendment falls within the scope, and foreign filing particulars, whether it is checked or not. So these things need to be checked in or and objections will be raised in the first examination report. Next, please. Now, technical objections, it will contain the prior documents D1, D2, or what similar documents that are there. The novelty about objections, inventive step objections, industrial applicability are there, and non-patentability, which is the basic patentability criteria. Sufficiency of disclosures, clarity, unity, and definitiveness. This will be mentioned in the technical objection section. Next, please. Formal objections include the fees, timelines, forms, assignment, priority, power of attorneys, and all these things need to be mentioned in formal objections. Next, please. Other objections, foreign filing particulars. Okay, if the applicant has filed in multiple countries, so these details of those particular application numbers or publication numbers and what is the stage, what is the status of those applications updates needs to be filed in Form 3 at a period of 6 months. Co-pending applications and any amendments required in filing the APR that to be mentioned in the other objections. Next, please. A reply to APR. As I've already mentioned, the applicant get a 6 months and extended time of 3 and then 6 months also for filing to the reply. So in that reply part, the applicant needs to basically write their own version or their own arguments in response to the first examination report. What are the objections raised and how they may not be suitable for those applications, and like for example, in the objection they have mentioned that your application, the claims of their invention has got similarities with these features of the previous prior art documents. So then they can say what are the differences between that prior art documents as well as our claimed invention. Okay, and whether it is technically advanced or whether it is inventive step or whether it has got some inventive step or not, these things needs to be provided as arguments in the reply to the APR by the applicant. Next, please. Okay, so this was all about the patents filing and processing part. Now we shall very briefly discuss the startup ecosystem and how IP is shaping up this particular startup ecosystem. So as we have got the statistics, by 2023, India has 1 lakh plus registered startups. And as of now, it is the third largest startup ecosystem. And in DFID only, which is the nodal ministry or the nodal department for recognizing the startups, around 3,000 fintech startups have been registered. So it has got a very high growth from 2016 to 2023 as we are seeing. Okay, next please. Okay, so not only the growth regarding the startups, many of the startups have already become the unicorn. Okay, that means they have got a valuation of more than 1 billion US dollars. Okay, so they have many of the startups have already joined the unicorn club. Next, please. So, what are the benefits of startups in IPR domain? So, first is they can enjoy the reduced filing fees for examination as well as Form 18, 18A. They can also avail the expedited examination, which is Form 18A, and they can also enjoy or avail the government initiatives like startup intellectual property protection that will be discussed. And so, what are the definition? Like, who are eligible to apply as a startup or any small entity or educational institution in patent filing? So, for startup, it should be if it is an Indian corporation company, it should be registered in the Startup India initiative that is recognized by the DPIIT. If it is a foreign company, it should file the necessary documents, declaring their eligibility as per the Startup India initiative and submit a declaration. Next, please. For small entity, uh, mainly the MSMEs are there, and it should fulfill the criteria as prescribed under Section 7 of the MSME Development Act. And for educational institutions, that means any university or any institution established by Central Provisional State Act, and any authority designated by central government, state government, or union territories, it should be recognized by those authorities. Next, please. Now, regarding the IPR schemes for startup, we have got this first. We have got this SIPP or Startup Intellectual Property Protection Scheme. So it was launched in 2016 to encourage and facilitate IPR protection for startups. And the nodal department is the Office of the Controller General of Patents, Designs and Trademarks. And it provides the facilitators to startups for filing and processing of their patents, designs, and trademarks. So in this scheme, only the professional charges that are being taken by the patent agents or IP professionals or facilitators from the applicant, it will be reimbursed by the Government of India. And it aims to promote awareness and adoption of IPR in the startup ecosystem and for providing high accessibility to quality IPR. Next, please. Now, who can apply for SIPP? Any recognized startup recognized by the DPIIT can apply for the startup SIPP scheme. Apart from that, any Indian innovator who files an IP application through any TISC or Technology Innovation Center, they can also file using this SIPP scheme. Any educational institution can file through SIPP, or any other Indian applicant who have filed the international applications using India as an RO, they can also file. Next, please. Who can be a facilitator? So the IP professionals, for example, the patent agent, who are registered, they can only file a trademark agent for the trademark applications. Any advocate who is also entitled to file to be a facilitator, or any government department organization like TIFAC, NRTC, BIDAC, they can also file using. They can also be a facilitator for this SIPP scheme. Next, please. What is the fee structure of the SIPP, and that is what is the professional charges which are reimbursed by the Government of India. So at the time of patent application, for patent it is 15,000, for trademark 3,000, and design is 3,000. At the time of disposal, that is the final stage, without opposition. If it is without opposition, then 25,000 will be reimbursed, and if it is with opposition, it will be 35,000. And similarly, 5,000 for trademark and design, and 10,000 with opposition. Okay, so these are the fee structures. So thank you very much. This completes the second part of the presentation. And now I would request you to kindly move into the question answer session or doubt clearing session.
Hello. First of all, thank you so much, sir, for such an insightful session. Now, I request the participants, if they have any queries, they can type them in the chat box or they can ask them in the participants can type their queries in the chat box or they can ask them. Arnab sir, one question is there.
Yes, please.
It's on the YouTube. It is from Sapna Kondalkar, ma'am. She has asked that she has applied for email correction in Form 22 with due fee in August 2024 in order to get the design certificate by email. Sir, how much time will it take?
There is no such fixed time as prescribed in the rules, if I am not wrong. Okay, for further, she can also raise grievance in the registered email address of the design section. Okay, then they will provide an appropriate reply regarding this email change. Okay, and she will probably get that answer on the particular aspect.
Okay, sir, one more question is there in the chat box. Is it easy to crack the patent agent examination and what are the strategies to break the examination?
Okay, so about the patent agent examination, recently and uh, as, as of my knowledge goes, a very recent amendment has been made wherein they need to have the thorough knowledge about the Patents Act as well as the Designs Act also. Okay, so it is now conducted, I guess, in twice biennial. Okay, so the thing is that you need to have got a thorough knowledge about this two act. Okay, so if you have got that knowledge, then it is very much easy to get the to actually pass the examination and get the registration. But the qualifying the examination is very much essential if you want to get the registration certificate and practice as a registered patent agent. Because please remember that only the registered patent agents are authorized to represent the applicants. Okay, and no one apart from that, even the advocates also or any lawyer, they are also not eligible for filing and protection of from the starting from the filing to ultimately the disposal. Only the patent agent or registered patent agent is only authorized to represent the applicant during the stages of patent applications.
One more question is there, sir. Advanced में logo patent is legal or illegal?
See, logo, okay, or any symbol which may be related to any trade or any other things is not related to patent. Okay, it is related to the trademarks. If you want to protect your logos and other symbols and other business, things, that the appropriate IP is trademark. Okay, and they can definitely protect it in advanced stages also. If you have created anything, okay, it is your duty to get it protected, right? And you can protect it at any stages, and you just need to apply for the protection, and then it is the responsibility of that appropriate department to check whether that logo is resembling or any other or okay, whether it is clear and concise and all these things, whatever the standards are of trademarks are there. If it is fulfilled, then you can definitely protect your logos.
Thank you, sir. Anybody else want to ask their queries? Sir is there to answer. Sir, one of the participant is asking to repeat the same question. Is it easy to crack the patent agent examination and what are the
Yeah,
strategies to break?
one sentence replies that if you have the thorough knowledge about the those two act, Patent Act as well as the Design Act, okay, then it is not only act as well as the rules also, then it will be easier for you. Okay, you will need to practice the provisions of this act. okay, then it is very much easier for you to crack the patent examination.
What is the difference between patent procedure and patent process?
Okay, I guess he's asking about patent procedure. So these are more or less same. Okay, so how the application is processed from the start filing to the final stages, that is the first stage to the last stage. What are the steps or what are the intermediate steps that are present that represents the patent processing stages? And procedure is more or less same. Okay, what are the intermediate steps that are required from the filing to the disposal stages?
So thank you. Thank you very much, sir. Anybody else want to ask the question? May type them in the chat box or they can raise their hands. I think it's over now. So on behalf of everyone present here, I would like to extend our heartfelt gratitude to Mr. Arnab Bhattacharya for delivering such an insightful and informative session on patent application filing and processing. Mr. Bhattacharya, your expertise and clear explanations have greatly enhanced our understanding of the patent application process from filing to processing. The knowledge you have shared today will certainly empower us to navigate this crucial area of intellectual property with more confidence and clarity. Once again, thank you so much, sir, for such a valuable session.
Thank you very much. I hope the session is insightful, and definitely we shall look forward for further sessions in future. So thank you very much.
And at last but not the least, I would like to thank the participants for being there, for listening patiently and asking the queries. Thank you so much. Thank you once again.